Hi, everyone. My name is Gabriela Urizar, and I'm an immigration attorney at Manifest Law with almost 10 years of experience practicing immigration law, specifically focusing on advising the largest multinational employers around the world within the IT and banking industries. And today we're going to be answering some questions that we received in regards of the Visa Bulletin and also other questions in regards of the latest updates within immigration. So let's pull up the first question and see how we can answer that. Great. So what are the most important takeaways from the January Visa Bulletin across the employment-based categories? So let me start by saying that you have two charts, right? Every month, the Department of State puts out the Visa Bulletin. We're going to see two charts per category, per area. For example, family based and then employment based. But let's talk about the employment based. So we have the dates for filing and the final action dates chart. So the Department of State basically uses the final action date to establish who has availability for a green card, and that's when they can actually approve the green card. So if your um, priority date is current under the final action date, that means that your green card can actually be approved. Or if you are doing the process through the consular processing, that's when you can actually go to your interview and your green card can be issued. Now, USCIS indicates that every month after the Visa Bulletin is issued, they will make the determination based on whether they have leftover availability of visas and also the capacity for the staff to honor dates for filing chart to allow people who have priority dates current under the dates for filing to move ahead and apply for their green card application using Form I-485 if they're in the US, a work permit, and a travel document. So let's just preface it by saying that. Now, in terms of what are the changes that we saw in this Visa Bulletin, this was a great Visa Bulletin, especially for people who were born in India. And let's just get into more detail about this. The first observation and the biggest one that we saw is that under final action dates for India, we actually saw a massive movement of almost a year, about 323 days for priority dates. So it advanced almost a year. So this means that people who have a priority date on their final action dates that were born in India that now are current are able to now get their green cards approved, right? Because there is an availability. So very exciting news for people who were born in India for this Visa Bulletin. And we're going to link in the comments a guide that Manifest created for people breaking down all these categories, but also providing a lot of information in terms of how to view and how to use the Visa Bulletin. Another big takeaway that we saw is that EB2 final action dates for all other areas, India, Mexico, and the Philippines, that, as we know, have their own category, also moved up by 2 months. China moved forward by 3 months. And now for EB3 final action dates for China, it went up by 1 month as well. We saw a little bit of movement there. India moved up by 55 days. So great Visa Bulletin for people who were born in India. No movement really happened with other areas and Mexico and the Philippines. This is for EB3 category. Now for EB4 final action dates is we saw a movement of up to 4 months. Again, great news for people who are under the EB4, which usually apply for those who have a special juvenile status visa approved. Now for EB5, which is the investor's visa, again, great news for India. We saw a movement of almost 10 months. China moved forward by a month, and there were no other changes for areas like the other areas, Mexico and the Philippines. So these are the biggest updates and movements for the Visa Bulletin. Now, in regards of the dates for filing, remember, dates for filing, if your priority date is current under dates of filing, that means that starting January, you can go ahead and apply for your adjustment status, your green card, Form I-485, travel document, and permission, a work permit. So great news for people whose priority date is also current under the dates for filing, and they're actually in the US. And again, the link that we're providing breaks everything down into detail and provides when the dates are current for each category and each country birth. Which categories saw movement versus stagnation, and why does that typically happen at the start of a new calendar year? So from the information that the Department of State and the USCIS has provided, and you can find this on the USCIS website on their frequently asked questions, they talk about how they determine when visas are available or when they can allocate visas. And it looks from the information that they provided that they do an inventory every quarter. And I wrote down the quarters that happen for USCIS. The first one is October 1st, which we know is the start of the fiscal year. So that's when they do an inventory, right? The start of October, start of January, start of April, and start of July. So they do an inventory at the start of each quarter, and that's when they actually have a better understanding and visibility of how many visas they have available. And if they have more availability, that's when we see a progression of the numbers in the Visa Bulletin. And another thing to keep in mind as well is that all the categories and the visas that were not used under the family-based categories, they spill over and they get divided between the 5 employment-based categories. So again, we usually see a push and a movement in October, January, about April. That's when numbers usually pause, because it's when people have moved forward at the beginning of the year and apply for the green card application. So that's when USCIS has a better understanding of their availability, and they tend to slow down things. And then we see another type of movement towards the end for some visas. How should applicants interpret small date movements? Do they actually matter for planning? So, in terms of the actual formula that either the Department of State or USCIS uses in terms of determining when someone can apply or when to move forward for the dates for the visa, nobody really knows the formula that they're using. But from looking at past visa bulletins, when we see small movements and increments in certain categories, it's usually an indication that that category is going to move. It's going to move, and that people are going to be able to go ahead and apply. And I think this is important in terms of planning, because if you have a priority date that's close to being current, even if it's moving very slow and you're living in the US, I think this is a good time to have a planning meeting with your family, right? And have an understanding that, hey, we might need to apply for adjustment of status within the next 2 to 3 months, because our number is almost there. So in terms of planning, what does that mean for our family? Maybe we should pause trips internationally so that we're able to be on site to go get the medical exams and get everything ready. Maybe we shouldn't move, or maybe we should move. So in terms of planning, it is very important for people to monitor the numbers in the Visa Bulletin and have the understanding that as soon as the priority date is current and they're able to go ahead and apply, that they should do it within the month that's available. So for example, if someone is current under the dates for filing chart for April of 2026, it is highly recommended that they go ahead and they apply for their adjustment of status using Form I-485, and also for a work permit and a travel document, because it is not guaranteed that that category will remain open and current for February. So, and we've seen this in the past. I think it was in 2018 when this happened, where the EP1 category opened up for Indian nationals for a month. Thankfully, people know how this works, so they went ahead, and it was really hard, right? Like compiling all the documents, getting all the applications ready, and filing and ensuring that USCIS had the application before the end of the month. And then after that month, the whole category was shut down. So again, there is no guarantee that your priority date will remain open for the next month. So it is recommended that if you see that you're close to being current, or if you're current, that you start speaking to an immigration attorney as soon as possible, so that you're ready and you don't miss the chance of applying for adjustment of status. What will be a good time to go for the first time H-1B stamping next year, given all the visa appointment uncertainties, H-1B renewal in September 2026? This is a great question that keeps coming up, especially with what happened the last week in terms of people who were in India visiting family, but also because they had a visa stamping appointment for the H-1B. As we know, a few days ago, the administration came up with a new guidance that they will increase the vetting of social media for H-1B and H-4 visa applicants. So consulates don't have the capacity, right, to keep all the appointments and do this extra vetting and look at all the social media of every single applicant. So they, to free up some space, they pushed out visa appointments for people all the way until we saw people getting their visa stamping rescheduled to April. I saw some dates in May. I even saw some people that had their visa stamping moved to July, August, and September. So, with this understanding and knowing that the majority of the first half of next year will be booked for all the people whose appointments had to be rescheduled, I think it is recommended that you speak to, of course, the immigration attorney that's handling the H-1B, but having this understanding, it will make sense to first renew your H-1B and then make the appointment for the visa stamping maybe towards the second half of next year. Hi, I'm on an F1 visa. I'm an orthodontist. Will be doing residency in the US. Can I apply via the O1 visa? Can I open my own office with that and work in that? So the O1 is a great visa that actually a lot of people are not familiar with, and it gives a lot of agency to the applicant, right? Because you don't have to rely on the H1B, which is lottery based. So with the H1B, as of today, it doesn't matter how accomplished you are, it is a lottery. So you really are subject to the lottery and you don't have any say in terms of whether or not you get selected. Now, in terms of the O1, something to remember is the that you will need an sponsor to apply for the O1 for you. So this could be an employer, a company, or it could be an agent, right? So in terms of can you create your own company and then have that company sponsor you for the O1? Technically, yes, and there are ways to do it, but it is very important that you consult to an attorney before doing this because certain corporate formations do not qualify. Like, for example, something that USCIS looks for as well is that separation between the actual corporate entity and the foreign national. So, like an LLC, right? Like, there is a clear separation between the foreign national and the corporation. But then in your situation, it gets a little bit more complex because you need a professional license to be able to work. So I know that some states require for you to create a PLLC, which is attached to your name. So it is doable, but it is very important that you speak to an attorney before you establish the corporate entity that can petition for you. But in the meantime, as a student, keep building your profile. Something that I tell students that are thinking of applying for the O1 is create a blog, talk about what's going on right now in terms of dental health. Become an expert in your field, right? Like volunteer to be interviewed in podcasts, volunteer to go to conferences, to serve on panels, to be a trusted expert, bring a lot of visibility to your work and your knowledge. And this will be very helpful when you get to the point that you're ready to file for an O1. Can you explain the difference between final action dates and dates for filing and when each one really matters? Yes. So, like I said at the beginning of the video, we have two charts, right? For employment base, we have dates for filing and final action dates. Final action dates means that the government cannot approve your green card or give you your green card until your priority date on their final action date is current, because final action date tells you when they have the availability of the actual green card to give it to you, right? Dates for filing is when USCIS can actually take your application for adjustment of status, right? And but every month they have to announce that they will be honoring dates for filing. Otherwise, they will honor final action dates. But most of the time, they pick dates for filing. This is relevant, especially the type of process that you're doing. If you're doing getting a green card to the consular processing, meaning that you're abroad waiting for your priority date to become current, you have to wait for final action dates. But if you're in the US in another non-immigrant status and your priority date becomes current on their dates for filing, and USCIS says, hey, this month we're going to be honoring dates for filing, you can go ahead, apply for your green card application, work permit, and travel document, which is very important because I've had situations in the past throughout the years with clients who were maxing out from their H1B or L1s, right? They really didn't have any other avenue, but because their date became current, they were able to go ahead, file for the adjustment of status, file for a work permit based on that pending adjustment of status and a travel document. And then while after they file, now they fall into a protected status that's called pending adjustment of status, right? So even if their non-immigrant status maxed out or expired, they were not accumulating unlawful presence and they were able to stay and continue working in the US because they were able to file their application when the priority date was current. Hi, I lost my job on an H-1B on November 14th. Is it safe to convert to B-2 visa for additional time? How much savings should I have, and what would be the immigration cost to convert for change of status? Well, first of all, I'm so sorry to hear that you lost your job. That must be very stressful, especially if you rely on immigration status with having a job, right? In terms of the H-1B, you do know that you have a 60-day grace period to either find another employer who can file an amendment, change of employer, or change your status to another a type of visa, right? So in terms of looking for another employer, like I understand that the market now is a little bit difficult, and when employers usually hear that you need a sponsorship, it gives them hesitation. But I think in the way that you should present it is do your research, right? Be ready to provide them with what are the costs to hiring an attorney, what are the costs to paying the government fees, right? And also to let them know that you're not subject to the cap anymore, that they don't have to put your name on the lottery, like they just have to file an amendment, and then you will be able to work with them. So providing that clear communication and information has helped a lot of people who are looking for jobs right now that are relying on an H-1B. Now, in terms of the B2, this is a very common practice that a lot of people who run out of the 60 days do. Before they run out, they're able to file for a change of status in the US to B2, but you have to remember that USCIS has to physically receive the B2 change of status before you max out so that you don't accumulate unlawful status. And when you provide the application, make sure that you're clear about your intent of filing this B2, right? Explain to the officers that you're filing because you need more time gathering your affairs, ending the lease of your apartment, and all that information. It is possible some people have done that where before they run out of the 60 days, they change status to the B2. And then they are able to move back to the H-1B once they find an employer. However, there is a likelihood that USCIS will approve the new H-1B, but will send you to consular notification because of the gap, because of the B2 bridge that you utilize. It has happened in the past, and in this situation, the $100,000 fee could apply because they're sending you abroad. So just something to keep in mind. What is the wait line for Indians for a green card via O1? So the O1 is a non-immigrant visa, so it doesn't lead directly to a green card. So the O1 has non-immigrant intent, meaning that when you apply for the O1 or every time you come in the US with a visa stamp with the O1, you're making the attestation that you don't have an intent to live here permanently or work permanently. However, there are situations where clients do change their mind, right? And after being here for 90 days or more, they're like, hey, I actually want to stay here. So they stay here, they talk to an attorney, and then they start building their profile to apply for the EB1. So the EB1 is there's a category that's basically it mirrors a lot of the requirements for the O1. So what people do is that they utilize a lot of the evidence and information that they use for their O1, and they just revamp it and they apply for the EB1. And for the EB1, based on extraordinary abilities, you can also self-sponsor. You don't need an employer. Now, in terms of what is the waiting time for people who were born in India, you will be falling under the EB1 category. So if you go take a look at the Visa Bulletin and you look at the dates for filing, which is what I explained, or final action dates, if you want to know the overall understanding of when you can actually receive the green card, it will tell you what dates they're taking on right now. Is it better to apply directly via EB1 or first to O1 and then EB1? It totally depends on the client. I've had clients who've done both, right? I had a client who was a student. Usually, when you're on the younger side and don't have a trajectory or a career, it's a little bit more difficult to make the argument for the EB1 that you're extraordinary in your field because you don't have a lot of years practicing, right? So they get on the O1, they build their profile for one more year, 2 more years, and then they have a very strong profile to apply for the EB1. If you're currently have that level of profile where you could meet the EB1 criteria, you don't have to go through the O1. You can just self-sponsor for the EB1, but it totally depends on your profile, your career, your credentials. And we're also going to post a link in the chat for people who want to schedule a consultation with one of our attorneys. They're very skilled and they will be able to provide you to take a look at your profile and provide you with an assessment of whether your profile is ready for an EB1 application, or recommend to work on your profile for a little longer before you're ready to apply for the EB1. Is there a high risk in going from a TN visa to an EB2 NIW? Something to remember is that the TN is a non-immigrant status. So again, same thing that I spoke about in relation to the O1, right? When you apply for a TN or when you use a visa stamp with the TN, and you enter the country, you're making an attestation that you don't have an intent to live here permanently. So it is very important that if you're going to do this, to speak to an attorney because they will be able to guide you. Like, for example, you come here, 90 days pass, you change your mind, you want to apply for the EB2 NIW. You could technically do that, and people have done it and people have been successful, but you have to be very careful in terms of traveling strategy and planning. I used my 6 years on an H-1B and I'm awaiting perm from outside the US. Perm was filed in October, but 2024, but the September rule, H-1B hike directly affects my case. What are my options if my employer still files the I-140? You don't need to be physically in the US for the I-140 to be filed or processed. Like, you can continue to wait abroad until the I-140 gets filed and your priority date gets current, and then you go to the consulate. So another technique that people have done in the past that I don't think people are familiar with this strategy, especially if your company is a multinational company, is for you to go on assignment. For example, they have a branch in London. Go to London for 1 year. After you do that 1 year, either in a managerial role or a specialized role, you can come back into the US with an L1, which will buy you time to be in the US and be able to adjust status when you're within the US. Why does USCIS sometimes allows filing under dates for filing instead of filing action dates? They do this when they have leftover visas that people didn't take, or when they have the ability with the personal to take on applications. But again, just because they allow you to go ahead and apply for your green card doesn't mean that it's going to get approved, right? You still need to wait for final action dates for you to actually have the ability to get your green card approved. Okay, let's take on the next question. What is the wait line? Oh, this was already answered. Again, you will have to convert to AB1. go look at the Visa Bulletin for EB1 category for people who were born in India, and then final action dates. So when people ask, hey, what does it mean when a priority date becomes current? I like to explain to them that their priority date is like their ticket online, right? So you have a priority date. You have to monitor the Visa Bulletin. If your priority date becomes current, meaning that your date falls on the date that's listed on your category or before, that means that you're current. That means that you're able to go ahead and either apply for your green card application if you're in the US and you're looking at dates for filing, or receive your actual green card if you're on their final action dates, right? So it is important that you continue to monitor it, and the numbers move based on the availability of green cards that they have for every section and every different category. If you were born in one of the countries that get your own category. I don't think my profile is ready for EB1. I'm applying to permanent residency. Will finish in 3 years. Will have OPT for 1 year for Indians. I would like to work as an associate and then have my own office. So I okay, which visa will allow me to do that? Can you go back to the question? Okay, so you want to open your own office and work, but you don't think you're ready for self-sponsoring. You want to, okay. So something to remember is that OPT is tied to an employer and tied to the type of work and your education that you're doing. So you have to be very careful about the um, opening your office and working for yourself, right? In terms of what visa could possibly help you, again, it's related to what I was saying about the O1, that if you establish the right corporate entity, it is possible that the right corporate entity could petition you for an O1 or either for an H1B. So again, I think this type of question is very specific to your situation. So it would be great if you're able to schedule a consultation and talk to one of our attorneys, but start thinking about um, O1, H1B, the right corporate structure. It could happen. People have done. How reliable are forward-looking predictions for Visa Bulletin movement? I think this question depends on the attorney and how comfortable the attorney feels making the predictions. I know some attorneys love math, and they're able to calculate, the percentage and how they spill over. And we're actually working on a document where we're gonna be providing more insight based on the prior Visa bulletins. In terms of how reliable are, again, nobody knows how the Department of State is making these determinations in pushing the visa numbers ahead or backwards. Um, but if you can take a look at, let's say, the last year, the last 2 years, on how the numbers have moved and what happens when a category moves forward aggressively, I think that can give you an indication. Also, if you, and all of this is public data, if you look at the availability of family-based green cards, right? How many were unused? Remember, they spill over and they get divided into the employment base. So all of that is taken into account, and we'll keep you updated in terms of the information that we're providing to our viewers and our audience and our clients. Yeah. If someone's priority date is closed within 3 to 6 months, what should they be doing right now? So this relates back to what I was saying at the beginning of the video, that if you know that your priority date is getting close to being current, I think it's important to have a planning meeting with your family in terms of what are you going to be leaving? Are you going to be, let's say, if your priority date becomes current next month, will you be able to gather your birth certificate, your passports, your taxes within days to be able to file the application as soon as the month opens up, right? So a lot of people wait until the end. Like example with birth certificates, to get a birth certificate in some countries, it's a hassle. So if you know this, then start planning now. Start requesting your birth certificate. All of these documents, you need to provide copies when you file for the application. However, when you go to your interview, you need to provide originals, right? So start thinking about securing either a certified copy or an original of your birth certificate and marriage certificate. Those are the documents that the government likes to see. If your passport is expired, get a new passport. Get a new passport, right? Like try to have everything ready so that when numbers open up, you're able to go ahead and file for your applications right away. I would like to know what are your success rates with EB1 and O1 visa profiles with Indians. Typically, how long is the processing? So we can provide more information on the link where you can look at our numbers, the different attorneys that we have at Manifest. But something that I can truly tell you is that all the attorneys that are working at Manifest right now, they're not only brilliant, they are very experienced, but they're also passionate about this work, right? They care. They care about the work. They care about helping professionals coming to the country and developing their lives here and making decisions based on that. We also have a very extensive pool of attorneys that, for example, specialize in EB1s for people in IT, or we have attorneys that specialize or have done cases for people in national security or different type of industries. So it is really cool because you can actually request an attorney that specializes in a certain type of work so that you can feel more comfortable working with that attorney. Okay, let's take another question. How do spillover visas work and how they play a role in the current bulletin movement? Again, this was something that I was explaining in terms of the spillover. The way that it works is that there's an actual regulation, right? Like a federal law about this that says that the spillover of the visas or whatever is left over will be from family category will be divided between the 5 employment categories, right? So again, we're working on a document that will provide more specifics about these questions that people ask in terms of how USCIS makes a determination, how the Department of State makes a determination, and all of this comes from information that the government has shared. But that's how it gets spillover, right? Whatever is not used in the family base gets moved towards the employment base, gets divided by the 5 different categories, and keeping into account the percentages, right, that is allocated per category and per country. In preparation to file the I-485, regarding the medical exam, where can I find the exact list of all vaccinations required? Okay, so in terms of this question, if you go to USCIS, you will find the list of the doctors or medical practitioners that are certified by USCIS to do this type of exam. So they will be the ones that are better suited to tell you what type of vaccines you are supposed to be getting, right? And just keep in mind that this doctor is the one that has to do the blood work. They're the ones that are supposed to do the medical exam. Something that I tell my clients is make sure you request a copy for yourself, because remember, when they give you the medical exam, it's going to be sealed, stamped, and signed, so you cannot open it and take a look, but you want to know what was put in there. So ask for a copy, and then don't open the envelope. Mail the envelope exactly how it is to USCIS. Why do countries like India and China experience a slower movement compared to the rest of the world? This is a really good question because there is higher demand, right? Think in terms of numbers. How many people live in India and China? And also in terms of STEM, um, China and India produce very talented scientists and people in STEM. Throughout the years, I've worked mainly with people from India, and their credentials are absolutely incredible. They're so impressive. So, in terms of thinking for employment base, right? Like, think about who is going to be taking the majority of the visas that are so specialized. All goes back to the number of people that live in those countries and the the number and the level of professionals that these countries are producing. So they're usually the ones that apply the most for these type of categories. So because there is a higher demand, that's why the government allocates certain time frame for people that were born here. And if you look back at the family based categories, you'll see that countries like Mexico also have a long waiting time because they're the ones that are usually demanding of, they have a higher demand for the family based green card applications. What is the right time to start working with an attorney when working on an O1 or EB1 visa? How far into preparing for the profile should we involve an attorney? This is a really good question. I think the mistake that most people make is that they wait until the very end to contact an attorney, but you can contact a few attorneys and have a conversation with them and, start looking for someone that you feel the most comfortable with and someone who understands your profile, right? I don't think it's never too early, right? Like, especially if you're a student and you're not ready to apply yet, but having a conversation with an attorney, having that attorney look at your credentials and help you, guide you in terms of defining a good area of expertise. What are the steps that you can take within the next 3, 6, 18 months, right? So it's, in my opinion, it's never too early. The sooner you speak to an attorney, the better chances you have because you can start implementing that while you're building your profile. Are we seeing any meaningful difference between the EB1, EB2, and EB3 movement this month? There was a huge movement for EB1 final action dates for people who were born in India. Let me just take a quick look because I have it in my notes here. EB2, it did move for, like, for example, for a few countries, like by 2 to 3 months, but we didn't see that much movement. And then the EB3 category, there was some movement for some countries too, but where we saw the biggest movement was in the EB1 category. And again, we're going to post the link for the very detailed analysis that the attorneys at Manifest were able to do for everyone here so that you can take your time, look at the numbers, and actually compare which categories move forward. For applicants born in backlog countries, when does cross chargeability help? I am so excited that you asked this question because a lot of people don't know that they can actually use the country of birth of their spouses to ask for a cross chargeability and for that country to apply. For example, I had a client who was born in India, but he married a woman from Switzerland, right? So they file a petition to ask for the country of the spouse to be used rather than India. So he wasn't subject to the long wait because Switzerland doesn't have a long wait. So it is very important to keep this in mind. How does USCIS decide how many visas to allocate to each category every month? It all relates back to demand. If there is a bigger demand for a certain country, then the number of visas will be smaller. And again, we do have an article about this, so we'll be posting that information. But there is a percentage component, right? And they cannot surpass that percentage that was allocated by Congress. So Congress actually was the one that set this percentage and this allocation of green cards for every category. When does it make sense to file an I-485 immediately versus waiting? I'm a big proponent for people to file for their adjustment of status as soon as their priority date for dates of filing is available. There is no harm, and there is no certainty that your category will remain open. So you're going to miss out on the chance to actually apply for your green card application and secure a work permit based on that green card application. And there is a huge misunderstanding for people that have an I-140 where they think that the I-140 has to get approved before they can actually apply. Your I-140 doesn't have to get approved, right? As long as your priority date on your I-140 is current on their dates for filing, then you're able to go ahead and apply for adjustment of status and work permit. So I think it's a great idea. I think having two layers of protection, having your non-immigrant status and then having your H-1B, your adjustment of status pending is a great way to protect yourself and have options. What are the biggest mistakes people make when filing their I-485 as soon as dates open? I think the biggest mistake that people make is waiting until the end. Remember that USCIS has to receive your application before the cutoff date. So it doesn't matter if you send the application the last day, right? If USCIS doesn't receive the actual package and application before the cutoff, then you don't enter in the in that month unless the next month is also current. So that's one of the biggest mistakes that I see, that people wait until the last day. Is there any update regarding a possible revocation or lawsuit related to the automatic H4 work permit extension? So, in terms of lawsuits, we are monitoring the lawsuits that are happening right now in terms of this type of issue, and also with the $100,000 fee. But we don't have any indication right now or any information. We'll continue to monitor this information. How do work permit and advanced parole benefits change someone's work and travel flexibility? Oh, these are great questions. Like I was saying before, if you're under an underlying status, and let's say you max out of your L and you max out, or you max out of your H-1B, having a work permit tied to your pending adjustment of status application could be huge, because now you don't need to rely on the H-1B. If the H-1B maxes out, then you don't have to depart the country. You can continue staying here. And if your work permit got approved based on the pending adjustment of status, then you can continue working. Now, in terms of advanced parole, the same, right? Like if you get an advanced parole approved, you don't need to get a visa stamp. You can travel with your advanced parole, right? So it definitely provides people with a lot more flexibility. Can filing an I-485 protect someone who is otherwise approaching a status cliff? Yes. So, like I said, if you're about to max out, but you were able to apply before that max out, you don't accumulate unlawful status. You are protected, and your status now becomes pending adjustment of status. You can apply for a work permit. You can continue working here. You can advance. You can apply for an advanced parole. You can travel. So it definitely gives people flexibility, and I saw it throughout the years of in my career, of people who were maxing out of their Ls and their H-1Bs, but because they were able to apply for adjustment of status, because before the max out, they were able to remain in the country and work and live here and continue their lives until their priority they got current and they got their green cards. What red flags should applicants resolve before filing adjustment of status? A big one is definitely criminal history. If you were ever arrested, even if it wasn't serious, even if it was dismissed, it is very important that you get a certified copy of your certificate of disposition that shows how the case was disposed, right? Also, to speak to an immigration attorney that has experience in criminal issues, because it's very important. They will be able to provide a memo to USCIS, making the argument that you are still admissible because it doesn't apply, and the law is very complex in terms of when you are admissible or not because of prior criminal history. So that's very important to keep in mind. Another red flag that you have to resolve is taxes. If you own taxes, if this is for people who have to pay taxes, right? If you own taxes, if you haven't resolved that with the IRS, very, very important that you resolve that before applying for adjustment of status. How does USCIS evaluate past status violations when reviewing an I-485? So USCIS, when you apply for an I-485, you have to undergo an intensive background check, but also they have to make the determination that you're still admissible per immigration law into the US, right? Because you're applying for adjustment of status. And to keep in mind again is if you have any gap of unlawful status where you did not have valid non-immigrant status, especially for work visas, which are less forgiving and more strict, you definitely please consult an immigration attorney, because you don't want to put yourself in a situation where you're not able to apply because you didn't apply the law correctly, right? Now, in terms of the bans, like keep in mind, if you spend more than 180 days in the United States, also over a year, different bans apply, and usually people have to depart and wait outside for the period of time that is imposed to them before they can come back to the US. USCIS has a memo saying applicants' country of concern is a significant negative factor. Can USCIS deny AUS change of status? If one is from a banned nation, will Supreme Court allow president to deny? So in terms of, I'm not sure about the exact memo that you're referring to, but there are a few memos that the president has come up with. One that came up a few weeks ago was that they were pausing of all adjudications of immigration benefits for people who were born in the list of countries, 19 countries that they deemed as high risk. This doesn't mean that they're going to deny these applications. There is no indication that they're denying these applications just because you were born in a country, right? They're just pausing the adjudication of these applications until they do a deeper national security background check and analysis. So this doesn't mean that your application is going to get denied. Now, in terms of can the president do this, or what is the Supreme Court going to do? I think this is a lot of speculations that I think it's not important to touch until it actually happens, because the administration has not said that they're going to deny the applications because you were born in a country. They say they're just going to pause the adjudication to do a deeper review. What type of H-1B violations are considered fixable versus risky? So it totally depends on your case, and it totally depends on the the status that you have, the type of work that you have. From my personal experience, I had a client that I got as a new client, and they had an expired I-94, an approval notice, and a visa stamp. And a lot of mistake that people make is that they don't look at the I-94. They just look at their approval notice and their visa stamp, the sticker on the passport. And they're like, oh, my approval notice says that, I have valid H-1B status until 2026, so I'm fine. But sometimes when you travel outside of the country and you come back into the US, CBP, the CBP officer that's admitting you, has full discretion to cut that status shorter. And many times they cut it shorter when your passport is expiring before your approval notice. So this client, they cut it short before the approval notice because the passport was expiring. So she didn't look at that. And that she had already overstayed. She had overstayed for like 2-3 weeks. That thankfully that was fixable. She was able to explain that she had an approval notice and she was relying on that approval notice. The application, the new extension, was approved, but she was sent abroad. So she was sent abroad. She went to the consulate. She explained the situation, and then she was allowed to come back into the U.S. So that was a mistake that was fixable, but it doesn't happen all the time, and depends on the officer. It depends on the attorney. One that I said is risky is working for other employers that are not listed on your LCA and your H-1B. And a lot of people make the mistake also of thinking that they can volunteer because it's non-paid. Well, actually, you cannot, right? Usually, when you volunteer, it has to be in a field or a job that regularly doesn't provide a pay, like helping in a homeless shelter or helping in a soup kitchen, right? The general rule is that people don't get paid when they work there. However, if you, let's say, go work and work in another company, but because you're not getting paid, you're volunteering, that's likely not permitted. So if you're thinking about volunteering, it's very important that you speak to the immigration attorney that's actually handling your H-1B, so that they can provide you with guidance and you stay compliant with your H-1B. How should applicants think about travel while adjustment of status suspending? This is a really good question, and there are a lot of misunderstandings going around. But now, in terms of adjustment of status, when you apply for adjustment of status, you there are two situations. Let's say you have valid underlying status, you have an H-1B, you have a good visa stamp. Likely, you're able to travel, leave, and come back into the US if you have a valid visa stamp, valid non-immigrant status, and your adjustment of status is pending. There's some situations when you're not really allowed to travel, like, for example, if it's about to get approved or adjudicated. And another situation is when people file for the adjustment of status, but their visa stamp expires and they max out of their underlying status, and they're only relying on the adjustment of status. That's when it's usually not recommended to travel, because if you leave, the officer could determine that you abandon your adjustment of status. So it's very important that if you don't have a valid underlying non-immigrant status and a visa stamp, that you apply for a travel document. Once your travel document is approved, you're able to travel in and out while your adjustment of status is pending. I think this is a very specific question that depends on the person's country, the country where they're traveling to, and the type of visa that they have. So if we can provide maybe a link talking about automatic visa revalidation, or if you can schedule a consultation with one of our attorneys for a legal question, we're more than happy to help you with that question. Is there any possibility about the work permit automatic extension interim rule getting revoked? Is there any possible lawsuit on this? So I am personally not aware of a lawsuit. This is something that you can look up. But in terms of could it get revoked, what we have seen, especially what I have seen throughout this year with this administration, is when sometimes or often the executive orders or the guidance get challenged in federal court, and federal court is able to place injunctions, temporary injunctions, preventing the administration from implementing the new guidance until there is a resolution on the court. So we saw this, for example, with the work permit for people who had a special juvenile status visa approved in June, July. The government came out saying that they were no longer going to give work permits for people in this category. It got challenged, and then I think at the end of November, federal court issued an injunction, and now is revoking the guidance from June and allowing people to still get work permits because they have a juvenile visa. So this is what has happened. It could happen. It's important that you keep monitoring the news in terms of what are the challenges and what are the decisions that these federal judges are implementing. Can green card holders with careless driving, alcohol related travel domestic flight? It totally depends on the conviction that you got, right? If you got a conviction, especially based on a DUI, it is very important that you speak to an immigration attorney before flying, and not just any immigration attorney, but an immigration attorney that is proficient and has experience handling issues with the cross between immigration law and criminal law. I hold a valid visa stamp and an I-94 valid until 2028. However, my H4 work permit is still pending. Could you please advise whether international travel is permitted while the work permit application is pending? So likely if you have a work permit that's pending, but you have a valid visa stamp, valid approval notice, people have been able to travel without an issue. But again, if you have an application pending, very important that you speak to an immigration attorney, because every case is different. What documents should someone always review with attorneys before leaving the US? Very important to, if you speak to an attorney before leaving the US, that you review your approval notice, right, until when it's available. Second, do you have a visa stamp? Remember, the visa stamp serves as a travel document and is the sticker on your document. And just because you have an approval notice that's valid for 2-3 more years doesn't mean that you're going to be able to re-enter the country if you don't have a valid visa stamp. So definitely visa stamp, approval notices. Also, if you were arrested or cited for a traffic violation, very important that you speak to an attorney before departing the US, because when you re-enter, you might face an issue with being admitted into the US. Should applicants consider upgrading or downgrading between EB2 and EB3? This has happened. People have been able to do that so that they're able to apply for their application based on the priority date, whichever is current. Something to keep in mind, though, is that if you're doing this, be sure to speak to an attorney, but also when you're upgrading and downgrading, you're changing the requirements of the perm job that you're applying for. So if you have done it several times, I think this could raise a red flag with the government in terms of what really are the credentials and qualifications that are required for this type of job. So just keep that in mind. What is the minimum number of hours that can be specified in the concurrent H1B petition? Again, this is very specific because we have to make an analysis whether you are doing two H1Bs, tax subject, or one exempt, one subject. So very important that you speak to an immigration attorney before making the determination. When does it make sense to file a second parallel petition? I think in a situation where, for example, you work for an employer and the employer is willing to pay for the perm process. But you also want a self-sponsor. So I think that makes sense to have the employer do the perm because the perm process can take up to 2 years for them to actually get the labor certification from the Department of Labor and be able to file for the I-140. So meanwhile, while that's happening, while those 2 years are happening, you can go ahead and file for a self-sponsor, either EB2 or NIW or EB1. If that gets denied, then you can always rely back on the perm, but you don't have to start the perm from scratch because it takes 2 years, remember, to get the labor certification. So that's a situation where it makes sense to file two applications at the same time. How do O1 and EB1 strategies fit into the long-term green card planning? This is a great question. The O1 and the EB1, in terms of long planning, this is a path that gives immigrants, especially younger immigrants and students, a lot of agency. You don't have to rely on a lottery like the H1B, right? Like you can actually be rewarded because of your accomplishments and your work. So if you're thinking of living in the United States long term, start working on your profile. Start making your recognitions known, right? Start networking, start developing connections with industry leaders that can vouch for you when you need the recommendation letters. Start showcasing your work if you're within the science, like start doing research papers, start building a Google Scholar profile. All of this is going to be very helpful when you're ready to apply for an O1 and eventually to an EB1. Are there policy or election year factors that could affect visa movement later this year? So I think in terms of making speculations for visa movement, I don't think any attorney knows how policy changes will affect. Remember, the number of visas and the availability is determined by Congress, and then the Department of State makes a determination of when the priority dates become current. I think what has more impact is how many visas are being used under the family-based categories, right? What is the demand like looking on their EB1, on their EB2? And we saw that again back in 2018. There was a huge demand in the prior years from like 2016, 17, 18 of the EB1 category. The EB1 category used to be current for everyone. So because there was such a big demand, that's when they retrogress and they started having a waiting period of time for AV1 category for some countries. So I think that has a bigger impact. Start looking, what are the numbers, how many petitions, and all of this is publicly available information. How many petitions are were filed this year for the AV2 NIW, right? How many petitions were filed under the AV1? So start looking at that, and that will help you have a better understanding in terms of the visa movement for each category. I am on an H1B and my spouse is on an H4 work permit. H4 work permit petition is currently in pending decision. Can I change job when a spouse H4 application is pending? So the H4, especially the work permit and the H4, are tied to the H1B applicant, right? So technically you could change a job while it's pending. Just make sure that you have a conversation with the attorney to see what is the best approach. Do you file an amendment with an extension and then include your spouse's H4? Or do you just file for the amendment and request the same date, right? So it really depends on your case and what strategy is best for you. But the H4 cannot be approved until the H1B is approved, and the H4 has to match, usually, generally, the validity of the H1B. We have time for one last question. What should people do now if their priority date is years away? So I think a good consideration that people could start having, especially if your waiting time is going to be very long, start thinking about maybe self-sponsoring. would, especially if you were born in India and let's say you're under the AB2, AB3, would self-sponsoring under the AB1 help you? Look at the numbers. What is the waiting time for someone that was born in your country and is under that category? That could be a helpful approach, right? Start planning in terms of employment. How safe and secure is your employment? What would happen to that I-140 if, let's say, you get laid off, right? Like, what is your relationship with the company? So these are very good questions to have. Also, another mistake that people make that I think ties back to planning long term is that they start that perm process when they have less than 2 years left in their underlying status. Like, for example, they're maxing out on their H1B in a year and a half. It's not a good time to start a perm. It is possible, right? And it will require a lot of strategy, but the best approach is to start thinking about perm when you just start on your H1B, right? Because once you file a perm, if you still have a year left on your time for the H1B, you can get a benefit, right? Like you can extend past the 6 year max um, with the filing of the perm if it's been pending for over a year, or if you get an I-140 approved, then you can extend that H1B in 3 year increments past the max out. Another thing that people don't think about when they get on underlying status is all the time that you spend outside of the US, you can recapture, you can get back. So if you can do family vacations, if you do trips for work all the time, all those days that you're spending outside of the US, you can ask for it back if you're under H1B and L1, and that will buy you time in terms of maxing out. But thank you everyone for joining today. And for more information, please reach out to Manifest at manifestlaw.com/webinars. We also have a lot of resources for you if you want to go to our page and explore. We have different blogs, we have resources, we have a lot of information, and everything is very updated. We try to provide information to our audience and our clients right away. So please go to the website. And if you want to speak to an immigration attorney and have a more tailored consultation, have them there, have them look at your credentials, book a consultation, and we'll be happy to chat with you.